Welcome and make yourself comfortable.
Thank you.
We will do a very quick round of introduction,
Okay.
just to warm up and for record. My name is Martha Comey. I'm the chairperson of the Judicial Service Commission, and I welcome you for this interview.
Thank you. Thank you, CJ.
Good morning.
Good morning.
Isaac Ruta is my name, also Vice Chair.
Thank you,
Good
Commissioner.
morning, Your Honor.
Good
Jacqueline
morning.
Gutia, you're welcome and all the best.
Thank you, Commissioner.
Good morning, Zilani Caroline, Commissioner Karibu.
Thank you.
Good morning.
Good morning.
Kisoto, Commissioner, welcome.
Thank you, Commissioner.
Good morning.
Good morning.
Omwanza Opati, karibu.
Thank you, Commissioner.
Good morning.
Good
I'm
morning.
Jokindum.
Thank you, Commissioner.
Good morning, Your Honor.
Good morning.
Anthony Mrima, Karibu.
Thank you, Commissioner.
Good morning, Your Honor.
Good morning, my lady.
Fatuma Sichali, karibu sana.
Thank you, Commissioner.
Good morning, Mheshimiwa.
Good
My name
morning.
is Olwande Evelyn. You are welcome.
Thank you, Commissioner.
Thank you very much, Commissioners, for that introduction. Mheshimiwa, if you can begin by telling us your county and your ethnicity.
All right. I come from Nyamira County. I am Akisi by ethnicity.
Yes, in your form, you indicate that you are a senior principal. I thought you were a chief magistrate now.
Yeah, by the time I had applied, I was a senior principal.
Now
but
you
I
are
am
a
now.
chief magistrate.
Oh, yes, ma'am.
So congratulations are in order.
Thank you so much.
This is a new one. About a month ago?
Yeah, 1 month ago.
1 month ago.
Yeah.
How does it feel to be a chief magistrate?
I feel good, and I thank you.
Uh,
I thank the Commission for that promotion.
Welcome.
Oh, okay.
Yes, now you tell us in 5 minutes what you perceive to be an ideal judge, and in that picture you paint for us of an ideal judge, we want you to tell us why you think you are suitable for that position, giving us the highlight of your key achievements, your experience, your expertise, which you think makes you suitable for this position. And also we want to hear from you your vision for the court, and knowing the challenges that that court is facing, you tell us whether you actually are suitable for it.
All right. An ideal judge has to have the following qualifications. Number one, he has to maintain integrity. Integrity is at the center of the discharge of administration in any institution. Integrity speaks it for itself, and without integrity, you cannot be able to discharge your administration of justice. That's number one. Number two, an ideal judge has to be honest. Honest in the manner you handle your matters, honest in the manner you handle yourself in public or in private. Number three, an ideal judge has to have skills, especially analytical skills. These skills will help you when you are writing your judgments, when you are discharging your mandate, even together with the rulings. You are able to analyze the facts married with the law. The other one is impartiality. An ideal judge has to be impartial. When you come across interests where the interests are competing, you need to disclose so that justice is not only done but must be seen to be done. The fourth one is propriety. You have to be very careful the way you carry yourself out in public or in private. It has a bearing on the administration of justice as a judge. You have to be competent. That's another ideal. You have to be competent. Competence means you must be able to demonstrate through your writings, through your behavior, and especially writings, that you are able to have a grasp of the law and communicate well, both verbally and in writing. Emotional intelligence is another issue which is very crucial when it comes to an ideal judge. You need to be stable emotionally and balance emotions together with the emotions of the others, and try to find your footing when you are doing the administration of justice. Now, I find myself, I consider myself fit for this position because of the following. Having been admitted in the year 1996 to the bar, and thereafter joined the judiciary in the year 2005. That was after 9 years as an advocate, and also from 2005 to this year, I've been in the judiciary. Now, cumulative years of 30 years, or 31 or so, has given me some competences. As an advocate, I handled so many cases of all types. I handled judicial review when I was an advocate, and I did practice at Kapsabet in Nandi County. So I used to handle judicial review cases in Eldoret, at Eldoret Law Courts together with Kisumu Law Courts. It gave me some knowledge on how judicial review cases are handled. Number two, when I was an advocate, together, including the current position I am, I handle cases, and the main object is fact-finding. So when you are trying to find out who is telling the truth and where justice lies, you need to be very thorough in your research and also analytical skills. Organizational skills has helped me for the time I've been in the judiciary. I realized, because most of the time I've been the head of station for the better part of my judicial work. And this time I realized that I needed to have some knowledge on how I can manage the staff. So this triggered me to take a master's in business administration in the year 2009 to enable me, give me skills on how to handle, and this can be evidenced by the courts I've worked, and especially when the issues of performance came in the judiciary. I was in Kilifi Law Court. I have my team. I steer my team very well. I have done outreach programs, which enables me to demonstrate that I am a team player. And as such, I know in the High Court, when I go to the High Court, that there are instances where benches have to be formed. So I don't work in silos, but I work as a team. Now, finally, you asked about the vision. My vision for the judiciary is anchored on Article 159. Number one, I have to handle cases without regard to status of the people appearing before me. And number two, I have to handle cases in a manner that it does not delay. I have to do it expeditiously. Another issue, I have to handle cases without regard to undue technical procedures. Yes. Oh.
Thank you, Chief Justice. Our civil procedure was first enacted in 1924, and thereafter it was in our statute books up to about 2010 when there was a significant amendment through the statute law amendment to 2010 that introduced certain aspects in civil litigation. Perhaps you can tell us, in your view, what was the great departure from civil practice pre-2010, and then after the amendment?
All right, thank you. 2010, we had Section 1A and Section 1B, which was incorporated in the Civil Procedure Act, and these are regarded as oxygen rules. This overriding provisions was enacted because of one simple reason: to give the judiciary or the magistrate or the judge some latitude so that we don't rely on technicalities, so that we rely on, I can say, just, expeditious, proportional, and affordable justice to the Kenyans.
So does a judge play a role in litigation, in civil litigation, to manage costs by the parties?
Yes.
How is that done?
Because when you look at Section 1B, there is the duty of a judge. And those duties are 5 of them. Number 1 is to ensure that there is just, first of all, from Section 1, it requires of the advocates and the litigants to assist the court achieve particular goals. And the goals are set in number 2 or Section 1B. And these goals are that it must assist the court to achieve a just and expeditious administration of justice, timely, and also leveraging on technology.
Okay.
Yes.
All right. Would a cost order be one of the tools that are used by a court in terms of proportionality, in terms of how you manage parties in civil litigation?
Yeah, it's one of them.
How is that? Because the normal rule is costs follow the event.
Yeah.
But would you say that now that amendment changed that sort of way of looking at things?
We have different types of truck cases.
Yes.
And then these truck cases they were brought by these rules now.
Yes.
And the purpose was to see whether we have the light truck, the middle, and the heavy truck. So that's where the costs come in now.
Okay.
So that when we have the light ones, they can go to small claims courts, and the heavy one has a different type of costs at the end of the day.
Okay.
Yes.
And lastly, for me, how does case management contribute to expeditious disposal of cases? And perhaps maybe in a very, very brief way you can tell us how, if you are successful in this endeavor, manage a court through the case conferencing to be able to, one, manage a cost, 2, timely resolution of disputes.
All right. I'm looking at Order 11. It's a very paramount tool for the courts to use. And at that stage, you're looking at the cases which have been filed. It gives you a forum to screen the cases which can go for trial and those which can go to the route of ADR. Now, this conferencing will assist to fast-track the cases instead of dwelling on miscellaneous issues or preliminary issues. At this stage of the conferencing, you are able to know what are the real issues for determination in a case. You are able to screen whether there are issues which really delay the cases, the hearing of the cases. Such issues like maybe preliminary objections, they are raising preliminary objections at that stage. You need now to have a conversation with the council, and they agree if we can have maybe stay of some orders which they want. But if it's issues of preliminary, for example, preliminary objections, what I use, especially in preliminary objections when they are raising those issues, I encourage them to understand, because we are all lawyers, we understand what a preliminary objection is. Mixer Biscuit versus Western Distributors, 1969, East Africa. I explained to them, plain objection is a pure point of law. You cannot, for example, give me a valuation report of a property and then you say you're raising a plenary objection. That is discouraged. So when we have issues like that, we are able to have a conversation with the council so that we can reduce those preliminary issues, and then we will direct to the main hearing. Then I can give at the end of the day the order that the case will proceed on this day.
Okay. Now, lastly, what would you say is your single achievement in terms of the bench? Because you said you joined in 2005.
Yes.
This is now 21 years.
Yeah.
Just one,
Yeah.
which you can demonstrate to us that this, in this case, I think I exercised. This is my most notable case, if I might put it that way, and I think I handled it well, and the parties were able to go home, satisfied that justice was served.
There are several cases.
Just one.
Just I can refer to one.
Yeah.
The famous case which had public interest of Mukwana. I think it's one of the cases I've given in my set of writings. In that case, there was commotion or demonstration over the country. And when a few of them were arrested for custody orders, it was like the nation was trying to see what's going to happen to these people. Somebody has been arrested from Migori, is killed at the Central Police Station. So in that decision, I spent time, and I did it intentionally for the purposes of the common mwananchi to understand how these cases are done. I was not doing for the case of the council only. So I started with the provisions of the Constitution, what the Constitution says about such cases. I came to comparing reasons, and I also came to the issues of how the international law also applies when it comes to releasing people who are suspected to have committed a serious offense. In that case, what I realized later in the day when I had delivered the judgment, somebody called me and told me, you can look at the TikTok. So I realized I had over 4,000 people in a few hours who are recommending that they have done a very nice thing. In that case also, because I know, I don't interpret the Constitution wherever I am. I gave some comments. If you look at the page 40 and page 41 of that decision, I said now it is time that the National Assembly and the Senate to revisit the issue of Cybercrime Act so that it is amended to suit the current trend of the world. The world now is changing. There is no turning back. But instead, I think later on about that case, Katiba went to the High Court. So they applied to have the whole cybercrime suspended because it is affecting especially the Gen Zs and the millennials, because this is a technological era we are in. And later I learned that that has been suspended for a while, but it is pending before Justice Mugambi.
Okay.
So I believe I contribute in one way or another, only that I cannot give structure in that is because I don't have the jurisdiction to do that.
All right.
Okay.
Thank you. Thank you, Chief Justice.
Thank you, Honorable Chair. Honorable Ondieki,
Yes, my lady.
I shall ask you one question,
Thank you.
but before we get there,
Yeah.
it was a requirement that for purposes of today, you bring your original certificates.
Yes.
And of course, you've given us those documents.
Yes.
All right. I was looking at these documents,
Yes.
and in particular, your KCE certificate,
Yes.
that is equivalent to Form 4. Oh, that was Form 4 rather.
That was from for then, yeah.
Yeah, that was Form 4. And I see that in the English language, you got a 9.
That's true, my lady.
And the 9, of course, was the last grade. It meant that one had failed in English. There wasn't any mark, there wasn't a 10. No,
It's
I want
true.
you.
It's true.
We're having this conversation.
I agree what you're saying.
Yes, yes.
Uh-huh.
And then Kiswahili, of course, you got a credit. That was credit 3.
Uh-huh.
And the sum total effect of it was that you got a division 3. And thereafter you proceeded to do your form 6.
Yes.
Correct?
Yeah.
And you did 4 subjects.
Yeah.
And in these 4 subjects, let me say you passed in 2. That was in history and Christian religious education.
Mm-hmm.
Is that correct?
That's correct.
We're just having this conversation
It
based
is.
on these
I
documents.
understand you, Malay.
And not that it means anything.
Okay.
Yeah?
Okay.
So you passed in history and Christian religious education.
Yes.
And in these 2, you got a D in each one of them.
Mm-hmm.
How many marks were those?
The total points at that time was 8, and the pass mark at the university locally was 9 at that time.
Oh.
Yes.
So A attracted how many marks? A attracted 6 marks.
Yes.
A attracted 6 marks, correct?
Yes.
So that if you did 3 principal subjects, the total marks, if you got 3 A's, was 18.
18, yes.
And then, of course, you're also required to do a subsidiary subject.
Yes.
So for this purpose, you actually got a D was 2 points. I did the same. Mine was also similar.
Yeah. But the total points for that grade is 8.
No, A is 8. If you got an A, A was 6. Correct? A was 6. So if you got 3 A's, you actually got 18 points. And you qualified to go to the university. But if you got a D, because we can graduate it from A, B, C, D, E, if you got a D, that was 2 points. 3. So D3 and then another D3, that makes a total of 6 points.
And the 2 for general.
So 8 points.
Yes.
Are you saying that those 8 points qualified you to go to the university?
Yes, it did, because in the UK, 2 principals and 2 subsidiary, you join the university. Also in India, it's the same.
Okay.
But locally at that time, they had put the ceiling at 9.
No, the ceiling was extremely high.
No,
To be able to do law,
during my time, okay.
to be able to do law,
Yeah,
one needed to get 16 and above.
that's true.
Yeah, so if your total was 8, that was actually quite low.
Yes, can I explain? Can I explain something?
Yes, please.
When I went to India, I studied with Bachelor of Economics
Okay.
before I could join law. So the first degree I did in India was Bachelor of Arts in Economics, after which I was able now to join LLB, which I did for 2 years, and then the special LLB 1 year, and then eventually I came back to Kenya School of Law. And the goodness is this: when I came to Kenya School of Law, we had Justice Njagi as the principal then when
Yes.
I joined.
Yes.
Those who came from India were given 11 papers to clear,
Okay.
within that period of time. And the locals were given 4 papers from the UON.
Yes.
You can't believe that I cleared them at one sitting. And my classmate, in the same room at the hostels, Valley Road there,
Yes.
he cleared only 2. He had to repeat another 2.
Right.
And when I was given the certificate by Justice Njagi, he told me, you are going very far.
Okay. All right. I mean, I don't by any means doubt
Yes,
what you're
yes,
saying.
yes.
But now I'm just looking at these documents that you've given us, and that's why I'm asking you these
That's-
questions based on what you've given us.
That's true.
And of course, you're saying that you went to India, you did another degree as a first degree, and subsequently did a law degree. I
Yes.
understand all that.
Okay.
But I'm just trying to understand the basis of it all, and you're explaining it. Because even then, at the Kenya School of Law,
Yeah.
you needed to have passed English, and not just with a credit, but with a distinction to be able to take law. But it appears like in your case, because you got a 9, the circumstances may have been different. I don't know.
Yeah, during our time, you can join law at the Kenya School of Law with all the backgrounds of the documentations that I've demonstrated there. And I am aware of this decision last year, but that is last year, so the law cannot apply backward.
So you're saying that during your time, you
Yes.
could actually join the Kenya
Yes,
School of
yes,
Law,
yes.
even if you had failed in English?
To our giving other consideration, not really failing in English alone, because I've seen what I've gone
I mean,
through.
the main consideration was not whether you passed English or not.
I don't know what they considered because they admitted me.
Okay, fair
Yeah.
enough, and
Yeah.
so much for that.
Yes.
So let's move on and fast forward. You're a judge. You've been successful, and you're a judge presiding over a matter. In this case, it's an application for review.
Okay.
An objection is raised that there is a notice of appeal that has been filed in the Court of Appeal. No appeal has been filed yet, but it's simply a notice of appeal that has been filed.
Yes.
And the defense counsel is saying that this matter is not properly before you
Okay.
because this is a review application, and he thinks or she thinks that you should down your tools. What would you do in a situation like that?
Thank you. For the Court of Appeal to assume jurisdiction, there has to be notice of appeal. So immediately the notice of appeal has been filed in the Court of Appeal, it triggers the court to have jurisdiction of the matter. Now, I'm trying to think this way. If now there is a notice of appeal at the Court of Appeal and it has assumed jurisdiction, do I have parallel jurisdiction to proceed with the review when there is already the court has been admitted or jurisdiction has been triggered in the Court of Appeal? So I believe I'll not handle the review because it's like two parallel courts handling the same case.
Supposing the matter in the Court of Appeal is then finalized, can you revisit that review application?
No, how do you call this term? I lack jurisdiction.
Okay.
Because already there's another jurisdiction.
You are looking for the term your functus officio.
Functus officio, yes.
All right. Thank you. That's all from me.
Thank you, Honorable CJ and Mheshimiwa once again. Welcome. First, I listened so intently on your academic journey, and I should congratulate you.
Thank you.
For the effort. It appears you are so determined that at come rain sunshine,
It's true.
you have to get into the legal profession.
Okay.
And you managed.
Thank you.
Congrats for the effort. I'll take you through what used to be called a writ of habeas corpus, but now under 2010, it's now a right of habeas corpus. You are aware of that, maybe?
Yes, I'm aware.
What is it about?
Produce the body whether alive or dead.
And it refers to?
It refers to a person who has gone missing, and there is an application made for the DCI to produce because they are responsible for protection of people and property.
Okay. Now, I want you to imagine you're seated as a High Court judge.
Yes. And
it happens that someone went missing.
Yes.
And the circumstances are that it was alleged that this is a person who was engaged in terrorist activities, and those activities led to the killing of 3,000 people
Yes.
at a go. And after a couple of days, without the family members knowing the whereabouts of their kin, they come before you with an application for habeas corpus. The DPP opposes that application and says, in public interest, the law enforcement officers have to be given time, because we are looking at the loss of 3,000 people as a result of activities connected to this person. And as DPP, we are aware that if this person is produced in court, he or she will be entitled to bond. But we do not want to deal with that issue now. So our prayer is you decline the habeas corpus, give time to the police, as and when they finish, they will avail this person in court, because of all that, because of public interest. How will you handle that application?
I'm looking at it in two ways. Number one, under Article 24, this is one of the unlimited right to a person, which is one of the four: fair hearing, substitute in slavery, human indignity and harassment, and the habeas corpus. They have that list in that part. So they're supposed to be produced. It's supposed to be produced. There will be no... Let him be produced within 24 hours and the court will deal with it. Now, the other way I'm looking at it is if they're supposed to be produced for the purposes of further investigations, then you are invoking Article number 49. If the DPP have reasons compelling that it should not be released on bond and bail, it has to have compelling reasons. So the compelling reasons are the ones which you can, the court will consider whether they are really compelling for this person to be continue to be held in custody. Hopefully, they are doing the investigations.
Okay, so you take the position that you will allow the habeas application, the person be produced, and if they want to oppose bond, it is as and when.
Yes.
Okay, thank you.
And I round the case of Danson.
No, it's okay. It's okay. It's okay. As a trial court, you are a trial court.
Yeah.
You deal with criminal matters.
Yeah.
Have you encountered the doctrine of reasoned possession?
Yes, I have.
What are the ingredients of that doctrine?
All right. Once the prosecution has led evidence and confirmed that the thing that was stolen, for example, is something which is stolen,
yes,
belongs to the complainant.
Yes.
Once they have proved possession, they have proved ownership.
Yes, ownership.
Number two, they have to prove that it was found in the possession of the suspect.
Thank you.
Or maybe his friend who knows that it is in the possession of the...
Yes.
Then, under Section 111, subsection number 1 of the Evidence Act, the accused person is supposed to give an explanation which is plausible,
yes.
Why, how it came about that document. And so we say it is a doctrine of recent possession. This arose from one of the cases in the UK.
No, it's okay.
Oh, okay.
And of course, the fact that the item or the property must be proved to have been recently stolen or gotten lost.
But also movement makes movement also varies with the time.
Okay.
With which the document moves from one place to another. Okay.
Precisely, Your Honor. Thank you so much. I wish you the very best.
Thank you.
That's all, Honorable Sergeant.
Thank you, Chair. Good morning once again, Your Honor.
Good morning, Commissioner.
I have gone through your sample writings. I know you are at the criminal court because all the sample writings are criminal decisions.
Yes.
When was the last time you handled a civil matter or ELC or ELRC?
Maybe 5 years ago, 6 years ago.
Okay,
yes.
That's understandable. So looking at your sample writing, Your Honor, they demonstrate your ability to clearly identify issues and you're able to make sound application of statutory and constitutional principles. They show your strong command of evidentiary analysis and proper use of comparative precedents. I see you make use of not just decisions within the country, but you've cited decisions in other Commonwealth countries.
Yes.
So the tone is impartial and restrained, and your conclusions are clear and well reasoned. I have noticed your writing style. I call it purple prose, where you use flowery language. And at times, people argue that when you do that, you may lose the readers. So if appointed as a judge of the High Court, how are you going to ensure that your decisions are clear and precise? Because when you use the ornamental language, which I call purple prose, people can get lost, and you may not even have enough time because of the workload in that court to start using that type of language.
Okay. I hear your concern, the Commissioner. Last time I was here for the promotion to the CM, the same issue was raised, and I was advised by the CJ to avoid more on those and go straight to the issue at hand. I have changed since that time. I'll ensure that I go to the point straight away and add to the issues as required, and then thereafter I'll refer to those other decisions and precedents to assist me. So I took that in last time I was here because it was raised a concern to the CJ.
Okay, good
Yes.
to note that.
Yes.
The second question is a scenario. You have two unmarried persons who have lived together for 20 years and have been blessed with children all under 18 years. During that relationship, they bought property and had that property registered in the name of the lady. After several years, they choose to all go their separate ways. The man says, I need part of that property because I contributed to its acquisition. What recourse does he have? That is question number one. And then number two, the lady says, these children are mine. According to our customary practice, the children belong to the wife, to the woman. The man wants custody of the child and is also demanding that the woman supports in raising the children, maintenance. How would you go about that case?
All right, I looked at this way. Those are two separate issues. There is a matrimonial property involved here, and there is the children case, which is a province of the children's court. In respect to matrimonial property, I believe the decision of Ogetonto vs. Ogetonto has given out, set out the guidelines on how this is going to be distributed. It is no longer 50-50. It's going to be distributed on account of contribution.
Okay, just taking you back, would
Yes.
the property, the one they acquired, would you equate it to matrimonial property? What is your definition of understanding of matrimonial?
Yes, any property acquired at the marriage, during the marriage, is what is referred as matrimonial property.
These couples were not married under any recognizable regime, marital regime.
All right, and then they can dispute in terms of they were like partners then, because marriage envisages matrimonial property envisages first there has to be a marriage.
Okay, so in this case, there was
no marriage, and
yes.
then it will
So
be based.
what recourse does the man have against the lady?
It will be considered like a partnership. So they have to show what contribution he had. But if the lady had more contribution, definitely the lady will take. If it's maybe 78%, that will belong to the lady.
So I'm waiting for a word when you say partnership. So partnership in what recourse do partners have in the event their relationship is severed?
It is based on what they had agreed on how to control their lives.
Okay, you may look into that.
Okay.
I agree with you with the girls to responsible. They are not married, but there is a word I was waiting for you to say. And how about the children? When the wife says, "And our customs," I remain with the children.
The children
and
is...
we are not married anyway.
Okay. Children are... the provision for the children is Article 53. It doesn't go to the customs. Because we have the article itself, together with the Children's Act, which guides or which provides for custody and the maintenance of the children. And so if there is a custom which is inconsistent with that law, Article 53, then it is void to that inconsistency. So if she cannot say that according to our customs, children are supposed to be maintained by us, it's not possible because that custom is inconsistent with the Constitution.
Does it matter that they were not married?
Yeah, it doesn't matter whether they were married or not. The children have nothing to do with their marriage.
Okay, thank you. I wish you all the best. Thank you, Chair.
Yes, reading your samples, as Commissioner Nguti has said, is interesting. You have a very poetic style.
Yes.
And I hope even as you restrict yourself, you do not also lose. Sometimes it's also, it can be interesting to read.
I hear you.
Is this, does this mean you read a lot, or you, is this creativity, this poetic style? Is it how you write from what you read, or are you a creative? You appear to be a very creative person.
Yes, that's true.
Okay.
Yes.
That's very interesting. Tell me, if I was to ask you 2 landmark decisions of the Supreme Court that you can recall, which ones would they be, and why?
Francis Kariuki Muriotetu.
Why?
Because the court was given the mandate now, the discretion in sentencing, so that the issue of mandatory was removed, though it was not removed, but the word mandatory was removed. But still it is there. It's one of the options of sentencing still.
In what kind of cases? In what kind of cases?
Only in murder cases. But for the rest of the cases, if there is an issue, it has to start from the High Court, Constitutional Interpretation, Court of Appeal, and if the Court of Appeal is satisfied, then it can scale it up to the Supreme Court to give the final word.
Okay.
Yes.
Do judicial officers have discretion to review sentencing in other criminal offenses?
No, we don't have jurisdiction. Judicial officers don't. It's only the High Court which has powers to review the sentences.
What about when it comes to minimum sentencing? Can a court amend the sentence that is given in law?
We're talking about subordinate court?
Any court. When it comes to minimum sentencing,
yes,
can a court amend the sentence that is provided in the law?
One of the principles of fair hearing is somebody is entitled to the most minimum sentence, unless it's going to be even lower than the minimum sentence that was given.
So let me give you an example. So
yes,
there is a case of defilement of a child under the age of 11.
Yes.
The minimum sentence is a life imprisonment. Can a judicial officer reduce that life imprisonment to maybe 30 years or 20 years?
He cannot do it.
Why?
Where the provisions of some acts have been given and the minimum sentence have been given, the magistrate has no powers to interfere with those provisions given.
Why?
I look at it that there was a reason why those minimum sentences were given. And going by the history of the Sexual Offences Act, it has saved so many our young people and the children. And so it was informed because it destroyed many children.
Okay.
Yes.
Also, that a judicial officer cannot legislate.
No, he cannot.
Okay.
Yes.
That is the first case. Another one, another landmark matter.
Another landmark case is the Speaker of the Senate versus the National Assembly in respect to allocation of revenue 2013, where the Supreme Court gave directions that the Senate is a party to any bill which affects the Senate, because they are the people who oversight the counties.
Can the Senate participate in a money bill?
That was the direction given by the Supreme Court, that they need, because that's the central power, that's the central jurisdiction oversighting. So any bill which affects the finance
Of the counties?
Yes.
What about where it is a money bill, not necessarily affecting the counties? There is a distinction.
I think money bill will remain just
For example, there are bills that the National Assembly has the sole discretion, or it's the sole mandate of the National Assembly.
That's true.
And there are others which must go from the National Assembly to Senate.
Yes.
Those are the ones you're talking about, the ones affecting counties.
Yes.
But there are also money bills, what is known as a money bill.
Yeah.
Can Senate consider money bills?
No, that is the preserve of the National Assembly.
Okay.
Yeah.
Thank you. That's all for now. Thank you.
Thank you.
Thank you, my lady. Good morning once again.
Good morning, Commissioner.
I have your performance report here from DISPOP. I don't know if you were served a copy.
I saw it last evening.
So is it accurate?
I believe it is.
Okay, so you have no complaint, I suppose, because it shows that you are doing well.
Okay.
Yes, out of the expected 14% of the total work output of the station, you are carrying 15%, which is commendable. That translates to 107% performance at the individual level. Your station has a long way to go when it comes to case clearance rate.
Yes.
As well as, no, it's doing well in court productivity, but the case clearance rate is rather low. Okay. So maybe that is the area you want to improve on. But that's not what I want to ask you about. I just wanted to mention that you appraised yourself of the last soldier report, I suppose.
Yeah, I've looked
the
at
24-25.
Yes.
Yes. You are coming from the magistracy. What was the case clearance rate in the magistracy in the last financial year, 24-25?
I cannot recollect properly.
What about the backlog clearance rate? You cannot recall.
Yeah.
Okay. Generally, how do we arrive at the case clearance rate?
The number of the cases registered divided by the number of JOs.
Case clearance rate, not the court productivity. Okay. The number of cases resolved divided by the number of JOs gives you the court productivity. What about the case clearance rate?
I'm not very keen on that.
Okay. So let me ask you something else. So you have succeeded, you are now a judge, you are posted to the family division, and an applicant comes before you and is seeking a grant ad colligenda bona. Grant ad colligenda bona.
Yes.
And in the affidavit in support of the petition or the application, they say that the deceased left behind children who need school fees. So they want to access the deceased person's account to be able to pay school fees. What would your determination be?
All right. Article Gender Bona is used as an interim for the purpose of school fees, maybe medication. But now, when you're going to give this, you have to cap what they really want for that purpose. and not to give a general so that it can work as a general, giving them a leeway to withdraw whatever they want. So you have to cap depending on what amount of the school fees they need, and then the rest will have to wait for the full grant to be applied for.
Okay, you've answered my next question, though you didn't get the first one correct. What I wanted to ask is whether you can use it to consume the entire estate.
No, you cannot.
What you have said is correct, but Adco Legenda Bona is not what you apply for when you want to access the account. You apply for a special limited grant.
Okay.
Yes. Thank you, and I wish you well. Thank you, my lady.
Thank you. Thank you, Honorable Chair, and welcome again, Mheshimiwa.
Thank you.
A few questions from me. I don't know whether you've come across this word, the whole of government approach. The government works as a whole.
Okay.
Independent and interdependent.
Yes.
Now, from this perspective, how should the judiciary relate with the executive and parliament?
Okay. The first thing I have to say here is we have three arms of government which are separate. But the separation is not absolute. They have to check and balances are there. So it's not completely that they are independent, they work without interactions with the other institutions. When you look at NCAJ provisions in the Constitution, it encompasses that we have to work in cooperation with the other institutions. So what my take would be that it's not complete separate, but we have to interact with each other while maintaining our independence, each maintaining their own independence.
How does the judiciary, at what point does the judiciary interact with the parliament, for example?
One, at the time of allocation of resources, because the parliament sort of oversees the monies that have been given to the judiciary. And number two, when we are talking about the Auditor General also, we have to interact with them because they have to see how we have used the funds that were given to the judiciary. So that's how checks and balance comes in, especially between the judiciary and the legislature. Yes.
Okay. That's correct. Now, who oversights the judiciary? Or how is the judiciary oversighted?
Oversight of the judiciary. I want to think of the following. Number one is by the Constitution itself. It provides that the powers or the authority that the judiciary is exercising has been donated to it by the people of Kenya. If they have been donated to it, then they have to work for the public interest. So that's one way. And also, under the Constitution, we have the principles under Article number 10. They also require whatever you do, you have to follow those principles. Those principles have been given by the Kenyan people in the Constitution. So basically, under that article, under Article 159, and Article number 10, Article number 159, even Article number 160 or 66, when you are dealing with this exercise, it is because the public have given this responsibility to the judiciary. The second way they do it is by the Judicial Service Commission. They oversight judiciary in the sense that they have the mandate given to them, like now disciplinary mandates or appointment of judges and magistrates, and also giving a policy. That's another way of oversight. The other one is also, like I said, the Parliament oversights, the Auditor General oversights, and another one is public participation. Public participation is one way that it oversights the judiciary. Like now, when this exercise was commenced by the Judicial Service Commission, I am aware there was public participation which was done. So that's the way they oversight it. Another one is the soldier reports, which is given annually. That's one way also the judiciary is oversighted. And also the judgments we write. There must be critiqued. Sometimes they are given the Court of Appeal for appeals and wherever. So that's one way also that the judiciary is being oversighted.
Okay. Now, my second and last question, could you pick 3 or 2 principles in chapter 6 and tell us how you have applied them in your day-to-day work as a magistrate? First of all, could you name the principles? What are the principles in chapter 6?
Chapter 6 has the following principles. Number 1, honest, integrity, independence, and being fair. Also impartial, and okay, those are the 6 I can 5 I can
Okay, just
recall.
speak 3 and tell us how you have applied them.
On the issue, I will pick on integrity.
Right.
Integrity is always the centerpiece of anything that we do as a judiciary. I've maintained the issue of integrity in the way I handle my matters. This one can be demonstrated by maybe if there are any reports maybe which is against me. I believe there isn't, because I've never gotten any report of the issue of integrity. If we go back to 2014, when we had vetting of the judges with the new constitution, I had no issues of integrity, and the recommendation by that board at that time, because I sat at one sitting, I did not, and I went through. They recommended that this person appears having high integrity, good oral and communication skills. Those were the comments made by that. And I remember the Chief Justice retired Tanzania saying, you write well, we understand what you do. Most of our, that's the words he said, most of our magistrates don't read this much. That's what they commented. So you have good integrity. And in any event, I've never received anything about the integrity. Another issue, the courts that I've worked, we have integrity committee teams where we have to sit and see whether there are issues of integrity. The other issue is about impartial. Impartial, this relates to conflict of interest, for example. When I'm handling my matters, I must make sure that I remain impartial in the way I'm handling my matters. Sometimes it happens, for example, you are in court and your classmates are there, they're submitting. I have to be very careful the way I'm handling my matters. Okay. And the issues of independence, I do handle my matters, judgments, writings, proceedings. And by the way, before I even forget, I do type my proceedings. And this has given me leverage, and I take leverage of technology, because immediately I type my proceedings, I'm able to publish them on the CTS. So even if today one could click and see, you'll get all those proceedings in the CTS. So the issue of independence, I am not under the influence of anybody within the judiciary or outside in the way I handle my matters. Not even my family members know the cases are handled in court.
Okay, very well, Mheshimiwa. I wish you all the best.
Thank you.
Thank you, Honorable CJ. Mheshimiwa, I have a few questions for you.
Yes, Commissioner.
How would you deal with members of your team that do not seem to be pulling their weight, and in return they keep pulling down the performance of the station?
Okay. If there are members in my team who don't carry the weight, I have a few areas I have to address. Number one, I have to find out the problem. I have to find out where the problem is. And by finding out where the problem is, now you'll be able to address the issue of their failure to carry the weight. Identifying the problem may take different ways, because there's some signals which will tell you that he has a problem, and that's why it's not performing. One, you may see issues of absenteeism, it does not come to court. You can see the issues of maybe having little interactions with the colleagues, then you have to know there's a problem here. So the first thing I have to do, identify where the problem is. And once I found where the problem is, if I am the head of station, I'll not address it immediately. I'll send this issue to the HR to be addressed there. The reason is this. It will happen that I'm the problem. And so even if I talk to this person, he may not even disclose. So the first thing I'll do is to forward this name to the HR to talk with them. The HR will be able to talk with the employee. And if it is my problem, it will be able to solve there. But if it's not, then the HR will tell you can have a talk one-on-one with the employee and then sort out the issue. That's one. Number two, we have to have a meeting when they don't pull. I find out where their problem is. Once we have a meeting, we are able to understand what is really happening. That's number two. Number three, we have to have an action plan now. Once we have sorted out the issue, we agree on which way to move forward. Number four, we have to keep on checking whether there is some improvement or not. And number five, what I can think is about recognizing now. If you find that he has improved, then you do the recognition, so that will motivate this officer to carry the weight.
Okay. If you're successful in this bid, you know that the biggest asset in any institution is the people,
Yes.
the human resource.
Yes.
So if you're successful, you'll be in charge of a team, and you'll be in charge of managing their work, their daily operations. What would you say are some of the emerging trends in the management of people?
All right.
Without expounding, you can just name any three.
Okay. Number one is AI, because AI will assist you to do small things as a team focuses on innovation and how to move the organization ahead. That's the trend now.
Mm-hmm.
Because when you look at the globally, for example, and most of the organizations, they have resorted to technology. In fact, we are one of the examples now here. We are resorted to technology to improve the services. And that's why when my first question answered, Commissioner, once I said leveraging on technology. So this one way. The other way is to be sure, to be aware that things are evolving. And when things are evolving, we have to move with what is happening right now, especially on the issues of technology. And another issue is, all right, three is about, for example, if you are handling issues with supply chain, for example, there's the traditional way we have been doing it. But now with AI or with technology, you are able to do it homemade on how you have to handle it instead of going the traditional way, which takes a bit of time. So you save on time.
Okay.
Yes.
Would you describe yourself as a leader or a manager, and why?
I'll describe myself as a leader instead of a manager.
Why?
The reason is a leader moves things. A manager keeps the status quo. With the new constitution, it envisages a transformative kind of leadership. So you have to go beyond text and let me say, as it were, you have to practice judicial activism, for example. So a leader moves things from where they are being static and gives impetus into the new ways of managing the organization.
Okay.
Yes.
Thank you. That's all. I wish you the very best.
Thank you.
Yes, thank you very much, Johanna, for answering the questions we've so far posed to you. Yeah, and I note you have since performed very well in English. to the extent that you are now a celebrated poet. That means someone can do very well if allowed to do what he likes.
Thank you.
And you seem to like law. Now, I have a few questions. One is, how is one thing, or what is one thing you could change about the judiciary today if you are given the opportunity to serve in this position?
I know in the High Court we have backlog. If given a chance to join the High Court, I'll work on the backlog. And this is how I'll do it. Immediately I go there, I have to look at the files which are pending. If there are more of preliminary files, issues touching on the preliminary issues, those are the first to exit from the system. How? I'll have to have a consultative meetings with the stakeholders, including the Council outside of Kenya, the DPP, for example, also. But especially in civil, those who are involved, especially the LSK. Once we agree, we can now work on our way. We can reduce these preliminary issues and go right away to the main hearing, because the Kenyans are waiting for the determination of cases. Most of them, they don't know what is a preliminary objection. They don't know what are these preliminary issues. So we have to go beyond and also ensure that we have targeted the main hearing. This is what I believe I will concentrate on.
Tell us a situation involving conflict management that you have experienced before.
I have never personally experienced the issues of conflict of interest, and if I see it from far, I'll be able to know. However, there was something which came as, it looked like a conflict, but actually it wasn't. There was an instance where I was handling a matter. After I've concluded, I was told, do you know what? That party comes from Nyamira County. I said, Nyamira County, yes. Then I said, what does that have to do with the Nyamira County? Because if he comes from Nyamira County is big. I come from a particular ward. And, it was like he won the case, of course. So I didn't know that there was conflict of interest. But had I known also, I think I should have just left that case. Had I known. But now you don't know people who come from your constituents, all of them, or from your county.
Of course, you cannot know all of them.
Yes.
Have you ever had to fire or recommend someone to be fired for poor performance? If so, how did you manage the situation?
I have never done that before. I've never had an opportunity to recommend somebody to be fired. But again, as a leader, I have to go through, I think that question is like, when they don't carry the weight, I have to go through those processes. I don't fire. Yes. I have to find out where the problem is. We have a meeting with the person. We try to find, maybe was it he expected, the expectation was not exactly what he wanted when he joined the institution. We try to find out where the problem is. But if it becomes endemic, and then maybe I have to report to the HR. But I've never done that before.
Okay, thank you very much, and we wish you well.
Thank you so much.
Mheshimiwa, I think now we are coming to the end of the interview.
Yes.
It's been very robust engagements with you this morning. I do not want to belabor any point rather than to encourage you continue having the passion and the drive that you have that has taken you to greater heights.
Thank you.
I remember you even recorded music, another hidden talent.
Yes, I did.
That the Honorable Commissioners may not know. You have a very vibrant choir. Is it still on?
It is. I moved from there. I don't know whether it's there.
Oh, it's when you were in Kilifi.
Yeah, I was in Kilifi. By the way, the Chief Justice, I know you may not remember, one of the recommendation I've given there is your letter that you wrote to me, the Chief Justice, that I did very well during the service week,
Yes, for children.
And I remember,
children matters.
Yes,
yeah.
And I remember you recommended us to go for benchmarking in the US. You asked me to give the names of the people who should go to the US. I gave out the names,
yes.
But immediately I was transferred to another court. So I was transferred to another court.
So you did not go to the US?
No, it's now I'm thinking you might consider. I was transferred to another court, and the names that I gave, of course, they went, and they continued to inform me what's going on. They're telling me how beautiful the place is, and whatever they were doing there.
So
but,
I'll make a mental note so
yes.
that you can also go to the US.
In addition, also, third year you came, the Chief Justice. I led the whole of the country. We were 2 magistrates, clearing cases below 2,000. From Kilifi, we were given an award. I think the report is in my... And also, when I joined Kilifi, a year before, I was number 2 the whole of the Republic in terms of performance. And during that year you came, my lady, I became number 1. We have these microphones that I'd introduced in Kilifi. Every court has this, and it was the first court to have such kind of microphones. Outreach programs, we did a lot when I was in Kilifi.
Yes, keep up the energy that I saw you with in Kilifi.
Okay.
I think now is the time we give a candidate an opportunity also to engage us, because we've been engaging you. So now the floor is yours.
Okay.
Yes.
I have no much to say, or that I can say when my name appeared on the list at some of the shortlisted candidates, it was very tremendous to my family. My last one told me, Daddy, have you looked at this? You've been listed at last. So it was quite overwhelming on me. I thank you, because I know that time I was SPM. So for you to shortlist me, you must have seen something in me. I thank you so much. I don't take it for granted.
Okay.
Yeah.
We wish you well on behalf of the commissioners, and we always encourage every candidate to keep up the good work. This is a very competitive exercise.
Yes.
We will get in touch with you when we complete it.
Thank you so much.
You are now released.
Thank you.
You can take your writing pad and your water.
Thank you so much.